Eilionoir, for anyone who doesn't know me, and I work with the Centre for Disability Law and Policy here. And together with Amnesty in this process of drafting the principles, myself and Anna Arstein-Kurzig, one of the researchers at the centre, did a lot of work in between those monthly meetings, trying to gather the consensus from people and start with a working draft of principles. And we ended up with 10 principles and many aligned key issues. And if you want to read the full document, it's on both Amnesty and the Centre's website. And I've also included it in the Google Docs for the summer school in this session under further recommended reading. So I'm not going to go through all of the principles. I'm just going to highlight some of the key messages from them and talk about the key challenges that we had in discussing these principles and how we got to what we have. So the first key message I'd like to outline is that our set of principles puts forward a universal understanding of legal capacity, that legal capacity is something that inheres in all human beings with or without disabilities, and that they have that legal capacity. So the only question is how to provide support to exercise that legal capacity, and that this is the understanding the legislation should reflect, that the legislation should not be providing a way to remove legal capacity from people. So we were very clear that we wanted a support model, and we wanted the legislation to focus on that and not to focus on deficits. Another key message, and this was one of the first things we established when we came together with the other organisations, was that the Irish legislation must reflect the Convention. Because one of the reasons for drafting the legislation in the first place is that Ireland feels it cannot ratify the Convention without amending its capacity legislation. So it would make no sense to then develop a piece of legislation which itself is a contravention of the Convention. And again, to reinforce this issue, as we've heard, the Committee on the Rights of Persons with Disabilities has come out with strong concluding observations in its discussions with Spain, Tunisia and Peru, saying that states must replace substitute decision-making mechanisms with supported decision-making. That's a very strong statement, and one we think is useful for Ireland to follow. The third key message from the principles is that there should be a right to support in the legislation. So this would provide a legal framework and recognition for supporters, as well as an obligation on the state to actually intervene to provide support to people who might not be very easily able to find a network of supporters or a community of support. So, for example, people who are isolated, who've been living in institutions for a long time, who may not have anyone in their lives except paid staff, there needs to be an obligation on the state to step in there to see if they can provide the kind of connections and supports that person might need to exercise and to express their will and preferences. Of course, we also wanted to address one of the specific deficits of the 2008 scheme on mental capacity, which allowed for informal decision-making to happen without any sort of process. So we said, of course, people use informal supports all the time, but informal substitute decision-making should never be allowed. Another key message from the principles is that using support should not be a reason to restrict a person's rights in other areas. So if I have a support network for making financial decisions, for example, that should in no way affect my legal capacity in terms of voting or marriage or any of the other decisions that I have to make. And then finally, in terms of the framework that we suggested the legislation adopt, we did in general follow a lot of Michael and Lana's work in sort of conceptualising it as person being legally independent, supported and facilitated as a last resort. We sort of conceptualised representative as part of supported. I see your reasoning for wanting to keep those two distinct, but for us that's where we placed it. We very carefully defined facilitated decision-making, and this was one of the real challenges of the process, because we wanted to make it clear that it is not guardianship and it is not the same as guardianship. And one of the easy ways to see how it's different from guardianship is that it does not require an assessment of capacity on the basis of which the person's legal capacity will be removed from them before you get a facilitator. So that was one of the big issues of debate for us, and took us a long time to get to that point. So the main challenges, apart from what I've just mentioned, I mean, the first challenge is when you're trying to move beyond the functional approach as it existed, say, in the Law Reform Commission's report in 2006. Trying to start from a place of saying, what if we just didn't assess capacity? What if we just provided the supports to people instead? And we do know from the Disability Act process what are the problems that happen when you put all of the energy and the resources into an assessment process rather than putting that into just supporting the person, starting with the person and supporting them. But of course, it's really difficult to sell people on the idea that you can provide that support without having an assessment in the first place. So that was a big challenge for us. The other question is, okay, well, if you don't have an assessment, what is the point? How do you define, how do you know when the state's obligation to step in happens? So what's the tipping point for the state to intervene and provide support to a person who has no opportunities for support, who has no support people in their lives? So that was another big issue for debate and a challenge that we wanted to address in the principles. Just on a practical level, even though we all came together because we wanted progressive capacity legislation, we came from very different fields, as Carol said: mental health, intellectual disability, older people, brain injury. So we had very different ideas about what progressive capacity legislation looked like. And even to those who were into the idea of supported decision making, we had difficulties in kind of agreeing on what that would look like. Especially one of the big challenges was, okay, support for most people, fine. But what about the people who have really complex and challenging needs? What about people who don't use a communication method that anyone else can understand? How can you support them? Is it farcical to talk about support there? Are you really substituting it? And trying to kind of address that issue and say, we think it is possible to support people in all sorts of circumstances. It's almost always possible to figure out a person's intention if you work at it long and hard enough. And then another challenge was to think about, because as Michael showed earlier, all of the issues that interact when you're trying to do a capacity reform. So looking at mental health, looking at adult protection, those were the two that we focused on, but we know that there are many more. I'm coming to the end, Jerome's pointing at his watch. And then just to say that the process itself was very rewarding, but building that community of support among such diverse organisations with very different understandings was a huge challenge. And we also had to address this sort of underlying issue of, we want speedy ratification of the convention, but we also don't want bad capacity legislation. And how do we get both at the same time? So that's basically a whistle-stop tour of the principles and the challenges we had in writing them. And I encourage you to look at the principles, and we'd love to talk to you more about this process, especially anyone who's here from other countries that are engaged in a similar process. Thank you.